study session on 13, please decide.
Thank you, and please be seated. Good morning, everyone. At this time, let the record reflect, we're taking up two actions. They're styled Commonwealth of Kentucky versus Stephen Eugene Lawson. Its case numbers 23 CR 165 and 23 CR 371. Mr. Lawson is present with counsel, Mr. Lavitt. On behalf of the Commonwealth is Mr. Young, Miss Young, and Mr. Lasowski. They're present here on the Commonwealth's behalf. I believe we're here today on motions that have been filed by Mr. Lavitt. I believe the first motion we probably need to address is the motion to dismiss based upon immunity. The court has reviewed all the memorandums that have been filed. I've listened to the recordings that the Commonwealth has tendered. I guess the first recording, I believe, purports a jail conversation between Mr. Lawson, and is that his ex-wife in that conversation?
Yes.
Okay. And the second one, I believe, is a recording from the trip back from Indiana to Kentucky.
That is correct.
Okay, very good. Now, my understanding is from looking at the record, I want to make sure we're on the same page here. The first offer of immunity occurred on June the 8th. Is that correct also? Okay. And it looks like, and I'm just trying to see all the different times that there were conversations after that. I've got down a June 8th conversation. Then there was a June 14th grand jury testimony. August 22nd, there was another meeting. September 12th, another grand jury on September 20th. Is that all the conversations that were? Okay.
I can go through, Your Honor, if you want me to.
Okay. I know there were conversations prior to the date of immunity,
Yes.
but after, I'm talking about the June 8th,
So there
were, what other dates were there?
and just the relevant dates would be the June 8th, which Your Honor has. There was a meeting on, this is not reported, on June 12th. There was a meeting between myself, Miss Young, the defendant, Mr. Lavitt, and Detective Luckett, where the offer of immunity was, the original offer of immunity was an blanket offer of immunity on June 8th. That was modified on June 12th to say that if he had participated in the murder in any way or hurt Crystal Rogers, then immunity would not be granted on that, but we would still work with him to try to resolve the matter. There was also an interview conducted, and I think Your Honor may have, on June 19th, did Your Honor?
I do not have anything about that. June 19th.
And there was a interview conducted on November 21st.
November 21st.
That is not.
Okay.
There was also a meeting, and Mr. Lavitt may remember the date. I think it was around November 14th at Kentucky State Police between myself, Mr. Lavitt, Mr. Lasowski, Detective Luckett and Hardin, and defendant Lawson.
And as I take it, there's no agreement that was ever in writing. Is that
That
correct?
is correct.
Okay,
Yes,
so
sir.
everything was an oral situation.
Yes.
From looking at the record, and I don't know if we were in agreement on this, my understanding is the agreement from looking at, all I've got is bits of transcripts that you all have in your memorandums, but when I read that, it looks like to me the offer was immunity if you're 100% truthful
Truthful and no omissions.
and not leave out anything. Is that your understanding of what the agreement was, Mr. Lavitt?
No, it's not.
Okay, well, what do you say the agreement was?
Oh, I say the agreement was what we find on these interviews. And some of these interviews have not been mentioned, Judge. Interviews on September 12th of 23, grand jury 9/12/23, KSP interview on 8/22/23, an interview on 6/14/23, grand jury on 6/14/23, and then a KSP interview on 6/8/23. So I'm not going to say what those, what the agreement was. I think that the parties' agreement is mentioned in these interviews. And in that regard, Your Honor, I have this flash drive memorializing those agreements. I'd like that to be considered in the record and I have
What
notation.
hold on, what are you trying to give me here? What is on that?
This is what we rely on. These interviews here, are the flash drive contents. And we have a notation as to those dates on this paper.
Okay, you provided that to Mr.
The
Young.
Commonwealth provided that to us.
I guess when I read your memorandum, the only agreement I'm seeing in there from what you're citing is that it's immunity based upon him being 100% truthful. Is there something on that tape that says something different?
Judge, in each interview, the deal that they had between themselves was recited. I'm not saying that each time that deal was memorialized, that it was the same. It certainly was not the same that you got to be 100% truthful. That's not what the agreement was each time that it was memorialized. I think the court has to look at all of the agreements that were made in all of the interviews and before the grand jury each time and make a judgment concerning the totality of all of it and not just one particular interview.
Well,
I mean,
I guess
they can't just cherry pick one particular interview and say, this is the deal. That's not what it was.
well, Mr. Light, let me stop you here. I've read your memorandum and I don't see anything in there where you're citing something that was different than what they're saying the agreement was. In your memorandum, is there anything in here showing a difference?
Nobody put their signature on it in writing. It was all governed by the Commonwealth. It was all led by the Commonwealth. It was all promoted by the Commonwealth. They had complete control over what that agreement was, and it's mentioned time after time after time in interview after interview. And so it may not be exactly the same. The words are not the same.
Well, I guess from what you have submitted, I don't see anything in here where they're saying anything other than, for instance, you in your memorandum on 8/6/8/23, it says Detective Hardin said, we are offering you the opportunity of a lifetime. You can say whatever you want as long as it's 100% truthful. Where is there something where they're saying something different? Because when I read your memorandum, I didn't see anything in here about a different agreement.
Judge, on this flash job, I mean, you're reading from what date are you reading from?
I'm reading what you submitted, and this was on June the 8th.
All right.
But I've read everything in your memorandum, and I don't see anything in here that's a different agreement in your memorandum than that.
Well, I hope the court's not going to bind me based on my memorandum only. My memorandum has to be supported also by these interviews and these two grand jury appearances. And I have that on the flash drive, and I'd like to submit that to the court because this comes from the discovery that they gave me. This is not something I conjured up. This is what they gave me.
Well, I guess, Mr. Lavitt, I have no problem putting that part of the record, but I would hope you would show me where on there's a different agreement, because I've got thousands of cases. I don't have time to watch multiple interviews looking for something different if you can't point out where it is. I mean, you need to point out where it is for me to look at that. I'll be glad to look at whatever you say is a different agreement, but I've read your memorandum and I don't see anything in it where you're quoting what's going on where there's a different agreement.
I think, Judge, I could be more pointed if I make myself clear. Each of these interviews mentioned immunity. And I don't think that I'm going to burden the court by presenting this flash drive. This is what I got in discovery from the.
I said, I have no problem with you submitting that, but as I said, I don't have the time to go through enormous discovery trying to find something different. If there's something different, I need for you to show me where it is, where I can go immediately to that and resolve this issue. But I think it's burdensome for the court for somebody to dump a bunch of interviews on them and say, hey, go find it. When I'll, if there's something different, tell me where it is and I'll look at it. I'll be glad to look at it.
They've pointed out maybe on one occasion where they said that you have to be 100% truthful. There are many other occasions where they talked about immunity and they didn't use those precise words. And I think, Judge, in my memorandum, I've mentioned that.
Well, like I said, I've read the memo. Okay. And I guess immunity is an issue that hasn't been addressed much in the Commonwealth of Kentucky. And I can only find one unpublished decision with any direction at all. And it is this 2008 decision. And I don't know if you pronounce it literal or literal. That's the case that I have been looking at here. And it begins by saying that in Kentucky law is unclear regarding the burden of proof for a defendant in establishing the existence of an immunity agreement. And it says the initial burden would be on the defendant to show the existence of an agreement by preponderance of the evidence. I believe there's clearly an agreement, but you're telling me it's different than what I've read in this memorandum. Are you wanting to put on any evidentiary proof here today, Mr. Lavitt, of a different agreement?
I think that my client agreed to be truthful. That's the extent of it.
Okay, do you wish to present any evidence today, any testimony or anything on, because my understanding from looking at it, the agreement was immunity if he's 100% truthful is what it looks like to me. But like I said, if you want to make that part of the record, I'll be glad to make it part of the record, but you need to show me on there where there's something different. But do you wish to have call any witnesses or anything in regard to the first step of the burden on the defendant of establishing the existence of this agreement?
Your Honor, I would just submit this flash drive.
And that's the discovery that the Commonwealth gave. Okay, if you want to make that part of the record, I'll make it part of the record here. Did you want a copy of what he's given me?
I'm gonna need it. I don't need a copy of it. If I can just get what's on there, I'll have it.
Okay.
That's-
Can I give this?
Does
Certainly.
that piece of paper have what's on the flash drive? Okay, I'll just make a copy.
Okay. If you want to bring it on up, Mr. Lavitt. You can just give it to me here.
There's a citation.
Okay.
This is the flash drive.
Okay. All right. In the Commonwealth's memorandum, they talk about a clear and convincing standard. Where did you all get that?
Judge, that actually is in the Ray's case, Commonwealth v. Ray's. It's a case where a defendant was trying to enforce an agreement with the Commonwealth. The court may be familiar with it. It's a fairly older case in which the defendant entered an agreement and actually the Commonwealth misunderstood who the shooter was in an incident. But the case goes back to clear and convincing as to showing that the defendant didn't do what he was supposed to do in the agreement.
Okay. Because what year was that?
If I can find it real quick, Judge. I don't know if I cited it. Actually,
I didn't see a cite in the memorandum on page 4. The Commonwealth indicates that that Mr. Lawson bears the burden of establishing it first, and the Commonwealth will provide clear and convincing evidence that Lawson is not telling the truth, but there's not a cite to what you're relying
And
on.
that does come from Ray's. I just got to find the site, Judge.
Because this lateral case that was from 2008 indicates that the burden shifts to the state to show beyond a reasonable doubt why the agreement is invalid. And at that time, they based that upon a decision out of Texas, I believe, is what the Court of Appeals did at that time. The only case I have found on a clear and convincing standard was out of Oklahoma. Is the only case I have found for clear and convincing on an immunity issue.
And I'll tell the court, the reason that that was in that case is they were relying on contract law as they analyzed the issue.
Your Honor, I believe that the case of United States versus Fitch, Sixth Circuit case, 1992, is extremely instructive on burden of proof and how the court should size up whether or not the Commonwealth has met its burden and whether or not any burden shifts to the defendant. I'd like to be able to talk about that Fitch case if I may.
Go ahead, Mr. Lavitt.
Judge, can I speak from my table?
Yeah, that's fine.
Thank you. Judge, in United States versus Fitch, let me just give you just factual basis. Fitch carried cocaine from Florida to Michigan, and then his cohorts were after him for the money and the cocaine that he left Florida with, and so he took off and went to Arkansas, and they followed him to Arkansas and put a gun to his head, and then he contacted the FBI and made a deal with the FBI and the United States District Attorney. The court held in that case concerning the immunity agreement, number one, that the agreement not to prosecute Fitch is governed by contract law, not the law of the marketplace, but actual contract law. Number two, that the breach of the agreement is governed by the agreement itself. And thirdly, that the government bears the burden of proof and that the defendant breached the agreement based on a preponderance of the evidence. Proof showing that there must be a material and substantial breach. The court held in Fitch case, which is a Sixth Circuit case, that the most important consideration was the incriminating nature of the proffered statement of the defendant and not the amount of the information provided. Therefore, the most important consideration in Steve Lawson's case, considering his immunity agreement, was the inartful and informal agreement between the parties. Wasn't reduced to writing. It certainly was inartful and certainly was most informal. The information provided by Steve Lawson helped in leading to the murder indictment of Brooks Houp and the indictment of Joseph Lawson. Number two, the defendant further assisted the Commonwealth in the investigation of the murder of Crystal Rogers, for which the government received the benefit of its bargain. Number three, the theory of immunity is that in exchange for the defendant's Fifth Amendment rights to remain silent, lest to incriminate himself, the defendant will not be prosecuted in exchange for inculpatory evidence that he gives in exchange, citing U.S. versus Black, which I've mentioned. Now, concerning the argument of the Commonwealth that Steve Lawson gave false statements, the question before the court is, number one, did any of those false statements mislead the Commonwealth? Number two, was the defendant's statement an attempt to minimize Steve Lawson's own conduct? And number three, The Due Process Clause and Fifth Amendment of the United States Constitution requires the government to adhere to the immunity agreement. Under the terms of the immunity agreement, the government cannot prosecute the defendant, which is the object of an immunity agreement. Now, Judge, we had many sessions, many of which I attended.
Let me stop here, Mr. Lavitt. I think before I even get to an argument, I need to give the Commonwealth an opportunity to submit proof here today as to why this agreement was not followed. So do you all wish to submit any evidence here today on that?
Judge, I can, but I need, part of the agreement was, or not part of it, the whole tenet of this agreement was for him to tell the 100% truth. It's on the August 22nd interview, just that, it was mentioned or brought up 27 times about telling the complete and total truth, to be completely honest. He's the one who has filed the motion claiming that he has immunity. He needs to tell us which of his statements were truthful. And once he tells us what statements were truthful, I'll be happy to submit proof to show that some of his statements, and I don't want to come in here. I'll tell you, there was no bigger fan of the defendant than me, okay, when it started. And because he's the first person who come in and told us that he was involved in the disappearance and helping with what the eventual murder of Crystal Rogers. All right. And we worked with him over and over and over again. We kept asking. The problem is after all these interviews and we started looking at it, he was minimizing his role. And he was telling a story where he was trying to minimize his role, which led to him providing untruthful statements. Now, did he tell the truth about some stuff? Yes, he did. We can verify physical proof. We can verify it by witness statements. Was Brookhouse responsible for this? Yes, he was. Can we show that through what Mr. Lawson gave us? Yes, we do. But you have to be 100% honest. I don't mind if they want to stand up and aver that everything they told us was truthful. I'll do it. I'll hold up my part of the agreement. But I can sit here today, Your Honor, and show you one of the defendant admitted to it. The defendant admitted to it, and I'm not going to use the language the defendant did, but the defendant's on a jail call as soon as he arrived in Nelson County, who tells the person, I think I messed my deal up with no lie. It's an admission. When he's being transported by Luckett and Hardin, the defendant, they say, hey man, you messed up your deal. He goes, well, I want to be on your team. And they're like, we told you you had to be 100% honest, and you weren't. And he goes, do you hear me arguing? So in order to come in here and say that was not part of the agreement is not being truthful. And by his own admission, he wasn't truthful. So they need to tender to the court or tell the court what in his statements were truthful. They all had to be truthful to get the benefit of the bargain. And Mr. Lavitt's right. This is contract law. This is just like the deal was on June 8th, it was blanket immunity. On June 12th, it was immunity as long as you did not hurt her or participate in the murder. But to get that, he had to be 100% truthful with no omissions. We can show omissions by what's been presented to the grand jury. And we can show, just based on his own admission of not being truthful, but two, we do have specific examples where he is telling the complete opposite of what he had said in a previous interview.
Well, I'm just trying to get this resolved today.
Yes.
And Mr. Lavitt, are you saying your client was truthful in all of the interviews? I just need to know what proof the Commonwealth needs to put on here today so we can move this along.
Judge, it's my statement to the court that, I attended numerous interrogations of the defendant at night at post in Kentucky State Police Post in E-Town with my client. And those sessions were conducted, they were filmed, there's audio. On numerous occasions during these interviews, the interview would stop. They were aggravated interviews on many occasions, a lot of yelling and screaming at my client, Detective Luckett, the detective. And there were breaks in those interrogation meetings, and that's not what they wanted to hear. And so they'd have a smoke break and they'd take them out in the hall and tell them what they wanted to hear. Now go back in there and tell us this and tell us that. And that's what he did. Now,
Yes, do you remember what my question was?
yes, I do.
Okay, what was my question?
Did he tell the truth?
Are you saying he told the truth every time, or I'm just trying to figure out what we're hearing here today?
In my judgment, Judge, and to answer your question, when I was there, he told the truth. And when I read the discovery that he gave me, I believe that he was trying to tell the truth. What they term that he lied or didn't tell the truth, I think that needs to be examined by the court, because they're making something out of what he said to make it a lie when he did not lie purposely. He told the truth because he was counseled to tell the truth. I told him to come to Lebanon, pick me up. We'll drive to Post 4 in E-Town and we'll talk about it. And all we talked about was telling the truth, give them what they want.
Okay, so you're saying he told the truth every time. So that's
I think
what,
he told the truth
okay, so
every
that's,
time.
okay, and that's what we're having a hearing
Let
on.
me, I just
He
want,
did not deliberately not tell the truth. And Judge, I wanted to talk further about.
I want to have a hearing, is what I want to get this done today. I don't want to keep talking, okay?
Very well.
Do we need to call proof then?
Very well.
Okay, is the Commonwealth ready to proceed?
and so I just want to make, we're gonna play it for you. But, so what defense counsel is saying is that the defendant told the 100% truth.
That's what I'm hearing.
Okay, because in his motion, and I know you're on read his motion.
I read the motion, yes.
And there's terms essentially used in here where he was indicted for tampering with physical evidence by allegedly assisting the moving of a vehicle. Where he states, Mr. Lawson said what Prosecutor Young and Detective Harden wanted him to say. Throughout the interview, Mr. Lawson was asked the police if he was telling them what they wanted to hear and telling them what he wanted to be on their team. The agreement was not to tell us what we want to hear. It was to tell the 100% truth. And they were always about Mr. Lawson giving the prosecutor and police what they wanted to hear. That's in his motion. In his motion, other than the cites, it not one time states that the defendant was telling the truth.
Do you wish to submit any
Yes, sir, I do.
evidentiary
I
proof?
apologize.
Okay,
Yes, sir, I know.
okay. Call your first witness.
And just, we're actually playing the interviews, not the whole interviews, but just selected portions.
Any objection to that, Mr. Lavitt?
I guess I just had to wait and hear what they have to say.
Go ahead.
The first two things we're going to play to put in the record, Judge, will be the defendant's call from the jail, as well as the conversation he had with Detective and Luckett and Harden while he's being transferred.
We're done.
Lawson to direct a call from.
Steve Lawson.
An inmate at the Nelson Police Department, Kentucky, carried by Combined Public Communications. This call is subject to monitoring and recording. If you now, to reject this call, charges for your call have been accepted.
Hello?
Hello. They moved me down here to Nelson County.
Yeah, I know. Brian told me last night.
Okay, what he had bad to say?
He didn't say anything bad. He just said that he had, you moved to Nelson County and that he was getting a hold of Ted Lavitt and letting him know that you were there
Okay.
and that he had the people to talk to.
Yeah, he was right about a lot of things. I'm gonna tell you he was.
What do you mean?
Well, you know, you said when I lied, it fucked my deal up.
I know.
But the one thing I don't want you to think, Phil, okay? The one thing I don't want you to think is that being totally truthful now, you've already negated your deal, okay? So being totally truthful now will only help you.
I don't know what you're talking about, sir.
Saying, Steve, is that the deal was based on 100% truth.
From the get-go.
We kept getting lies, and so the deal was off, right?
Oh.
We're negating, just simply saying that.
That's already negated.
And I've told you from the word get-go that I wanted to be on your team. Have I not told you
Well,
this?
yes, you have, you've also lied to us one time.
And did I disagree with that, sir?
So you have to understand our position.
But I'm telling you, I don't know
What
what
you say you want to be doesn't mean you are.
Well, okay, I understand.
Don't get
Judge, the first example that we believe to tender to the court was when the defendant was being interviewed on June 8th of 2023. And he was being asked whether or not Tammy Lawson, who was his wife at the time, was on the Bluegrass Parkway at the same time with him and Joseph Lawson picking up the vehicle. There's proof that based on cell phone usage, that we could show Steve Lawson was at mile marker 14. After he got off the phone call with Brooks' house, he drove in mile marker 14. Tammy Lawson was also on the Bluegrass based on cell phone coverage. We believe she was also involved in the crime. And just based on some statements the defendant has made previously, we believe she had knowledge, which eventually she passed away a couple of years later. So this is an interview where we're in the Kentucky State Police talking to Steve Lawson and asking him why was Tammy on the Bluegrass.
I do have a question there. Why was Tammy behind you?
What do you mean?
Why was Tammy 2 minutes behind you on the parkway?
It was mad. Told you. She was drunk, pissed off, always wanted to fucking fight. I didn't lie to you about that. Some of a bitch done draw a gun on me fucking 3 times. The whole time we were married, draw a gun on me 3 times. But that's neither here nor there, neither.
Correct. That's neither here nor
But the
there.
bitch
We're
was
not
just
into-
crazy.
Yeah, we're not into your domestic life.
No, she was just crazy. When she got fucking mad, she didn't give a fuck. She was hunting me down at any time, blow my damn head off. It's just that simple.
So you got 2 things going on. You got Joey calling you, needing a damn ride in the middle of the
And that
night.
motherfucking woman wanted to kill me.
Yeah. So,
Okay.
okay.
That makes some sense
Yeah.
to you. No, I don't mean, because that woman shouldn't want to kill you.
Well,
Anyway.
it is what it is.
Yeah,
She's
but
gone.
anyway, let's go on. That's a
Whatever.
fucking different story. She's
Yes,
been gone.
correct. So anyway.
Why was Tammy coming down there?
She's mad because I wouldn't bring her no more booze.
She was gonna chase you down the parkway?
She called a gun on me more than once.
Okay, so she chased you down the parkway. Or did she find y'all?
No, she went on back
wherever.
But did she find you?
No, when I got back to Bardstown.
No, but did she pass y'all?
I'm not for sure, sir. At that point in time, I don't know who passed, and that's a fact.
Why was Tammy on the bluegrass with you guys that night?
And we wasn't on no bluegrass with us.
Now, Judge, this next clip, the defendant has on the same T-shirt, but it's a different day. This is actually on August 22nd of 2023, and you can notice the difference. One, it's timestamped, and two, he has a cast, I believe, on his either right or left hand. But he is wearing the same clothes.
Why was Tammy on the bluegrass with you guys that night?
And we wasn't on no bluegrass with us.
Sure she was.
No, she wasn't. Hell no. No. Only place Tammy went with me and Joey was down on Boston Road, pick up the Chrysler 300 we stole back. Then we left there, went straight up to Thompson's Food Mart, and had to put gas in the car, cause it damn near run out of gas.
Tammy went with you guys when you picked up Joey?
No.
From the BG?
No, Tammy was not with me. Not that I ever recall my wife was ever with me. In fact, I think her and Joy and me, well, I'm not gonna say me, because I'm not sure if I was on the phone with her and family or not arguing with her. I'm not gonna say that. I could be wrong. But I think Joey and her was texting back and forth that, I'm thinking that's right. I don't know that's true. It's been a long time, but my wife, and as far as I know, was never on no damn BC with me at night. I think me and her done had around and around and around. I don't think we was nowhere near each other until I went back to the house and folks took her some booze and folks took her some cigarettes.
Well, I say,
There's the next clip is from an interview that was conducted on June 19th of 23 on Thompson Hill Road. And the issue is we were talking to him about the car, Miss Rogers' car had been taken to Thompson Hill Road. And we were asking the defendant his knowledge about whether he knew it was being taken to the Bluegrass Parkway.
No.
Yeah.
It's like, like I told him, we gotta get this motherfucker out. It can't stay here.
Was it gonna stay here?
All that.
What was the plan to do with the car?
That's the thing. All I know is I told him it can't stay here. Says it's going to BG. That's his words. It's going to BG. Well, then let's get the motherfucker to BG. Was it supposed to stop right there where it's supposed to stop? I don't know.
Acknowledging that he knew it was going to the Bluegrass Parkway.
That's it. We done discussed it. He knew.
Yeah. And this next clip is from
You want
September
every call in the
22nd,
background.
2023 at Post 4. Where he was also at that point, this is the last interview conducted at Kentucky State Police. And he was asked in that interview whether he knew what the plan was and whether he knew the car was being taken to the Bluegrass.
What date was that?
September 22nd.
You want every call in the background, is what I do. So I go out to Rich Thompson Ridge. I'm sitting out there, Thompson Ridge, George said, "It's car." I said, "That battery, and go back in over by the church." Well, he gets out and enjoy that people, the car can't be there. I told y'all that at the time. It's constantly, the car can't be here. When it fucked up, this car should not be here. But the car's got to go. So he drives out. I didn't know he was going to the Bluegrass. That's right. I did not know this.
Where he in that interview stated he did not know that Joseph Lawson was taking the car to the Bluegrass Park. And Judge, these are all one material, Because the Commonwealth at this point is trying to, we know the crime has occurred. He's told us the crime's occurred, but we're trying to figure out who's involved and in what sequence and what knowledge people have. And telling us that Tammy was on the bluegrass, and she wasn't on the bluegrass, that he knew the car was going to the bluegrass, and then he didn't know the car was going to the bluegrass. Judge, there's two, we just pulled out, there's numerous examples, but we pulled out 4. The next is an interview that occurred on September 12th of 2023, where the defendant is talking about the Bobcat. And the Bobcat, which is also referred to as a skid steer throughout the interviews, we believe to be used in the crime. We believe to be used, or was to be used in the crime. And so we were asking him about the Bobcat, in which he advised us that the last time he saw the Bobcat was on July 3rd, when he parked it down by a tree, which he's acknowledging that's true. And he didn't see it since then, that he believed his son stole the Bobcat. For the next 5 years, he blamed his son for stealing the Bobcat. So we'll play that clip right.
Got a Bobcat, alert, go back over here and like, no, it's this time of week, so you know, I took Bobcat over there, sit it underneath the tree. Keys ready, everything still in it, where it's at.
The next, in the same interview,
The skid steer didn't go to the bar. That skid steer was underneath that tree. That's where I left the skid steer underneath the tree. And I don't know where Rebecca's at. Right now, is on.
She been here.
No, that's not what I'm saying. I went back to get the skid loader, and I accused Joy of stealing it. But she wasn't even around then, and I told her time and time again, we needed the skid loader to do some work around the house, didn't have it. I said, that little son of a bitch fucking stole that skid loader, and I blamed him for 5 years for stealing this fucking skid loader.
No, Jeremy Thompson.
Well, I'm sorry, but I did blame him for fucking 5 years for stealing it.
Chairman Thompson went and got it and sold it to a guy and we have the skits.
Okay, well, I accused him of stealing it.
so the next conversation, Judge, is from the same interview, where we're inquiring to him about the phone call that was placed by Brooks Houp on July 8th of 2015 about the conversation where Mr. Lawson in the conversation states that he was calling Mr. Houp at midnight to inquire about an apartment, where Mr. Houp told him he would need to talk to Crystal and she was asleep and he would need to call back. And he's trying to explain, he tells us that that conversation, that was not the subject of the conversation about an apartment, that it was actually to tell Mr. Houp, there were a couple of different versions, that it was, the job was done or the car had been moved. So he's trying to explain to us later in an interview that him and Mr. Houp had talked about this 2 or 3 days later while he was using the Bobcat that he had not seen for 5 years.
We're gonna look at 2 or 3 things. I mean, because I can't, literally can't.
I understand.
Thank you. And been doing a little Bobcat work over, like I said, and I rode the Bobcat off Plain towards the block, and that's when I seen him. And I'd asked him previously, or maybe a week or so before that, about an apartment for my daughter. That evidence he kicked her out of one. I tried to get rid of it. But you can use this conversation, of the apartment to cover the phone call, this other phone call, basically. Which, you know, was a lie, but either way you look at it, that's basically the way it went. And I mean, that's just the facts of it, so. I mean, I'm not trying to sugarcoat it.
And Judge, the final piece I'm gonna play is him stating that the skid steer did not go to the farm. No, that actually was on there. And Judge, I would, if I can approach, please. I showed this to Mr. Lavitt. This was the interview that was conducted over on 21st. That was not reported, but this is an investigative letter surrounding that interview, wherein the defendant, for the first time, advises that the skid steer was actually being used up at Thompson Hill Road on or around the 4th, and that they were doing burning and digging with the skid steer. There is only one skid steer. The one that he claimed he didn't see after July 3rd. The last example that the Commonwealth would tender to show that the defendant did not honor the terms of his agreement would be the defendant was asked about doing work or communicating with Brooke Houp, and which he stated that he had never worked for Brooks Houp before. This is the only time he worked for Brooks Houp, and that he never communicated with Brooks Houp. If he saw him out, he would say hi. And this would have been around the time period of July the 3rd.
Your Honor, I just happened to look at that. I haven't seen it before today. I haven't read it.
Talk about this right here?
Yes.
You want to take a look at it then?
Yeah, I'd like to get a copy of it if I may.
I don't, he sent a copy of it.
I'd like to see that.
Sure, take a look at it. Uh-huh.
Here, Ted, I can give you one. I can just give you. And Judge, this interview, I believe, was on August 22nd.
Have you ever discussed one with Brooks before this, or ever worked before?
Don't recall ever worked for Brooks House before.
Have you ever spoken to him?
Oh, I've seen him at Lowe's and places like that. Everybody was on Lowe's. It's like I spoke to most of the contractors.
Okay.
I've never done no work for Brooks a day in my life. Y'all know that? That either one of you know this? That you've never? Tell my son he got hooked up with Brooks. I've never done any work for Mr. House, ever. All of a sudden, my son's like, well, Daddy, we got to do this. Okay, son, well, you know, that's fine. We'll go help this man. I don't give a shit. It's a job.
Now, at that point, the defendant has stated that he did not talk to Brooks Houp on the phone. He only saw him when he saw him out. He would say hi. He'd only worked for him on one occasion. And what the Commonwealth finds intriguing is when we looked at the defendant's call detail records, we couldn't look at his phone because the defendant had deleted 24 phone calls where him and Brooks Houp had talked since May and June. We couldn't look at Brooks Houp's phone either because Mr. Houp had also deleted the phone calls made that occurred between him and Mr. Lawson, which I do have the phone records for your honor. You have these, Mr. Lavitt, so.
My son.
Yeah, approach your
You
honor.
may.
And Judge, I also, and I've given the section lab, those flips, I know they're hard to hear. We've flipped those and put them, I was gonna ask for that. Yes, sir. Thank you. And Judge, we believe, there's numerous examples, but we believe those 4 examples, it only takes one where you're told that you have to tell the 100% truth and have no omissions. Whether material, not material, that was not our agreement. Our agreement was 100% truth and no omissions. You can cite case law that talks about contract law, but our agreement was 100% truthfulness and no omissions, which I think in those 4 examples, you see that the defendant was not truthful. And I do have the cite on Reyes.
You have what now?
Reyes cite?
Sure. What is that?
It is Commonwealth versus Reyes, 764, Southwest 2nd, 62, Kentucky, 1989.
So it predates the unpublished decision. Okay.
Yes.
Okay. Is that everything from the Commonwealth?
Is everything from
Mr. Lavitt, anything you want to point out from the discovery that you believe establishes that your client complied with this agreement?
The Commonwealth, from my reckoning, has presented on 4 occasions when they claimed that my client didn't tell the truth. On each of those 4 occasions, we vehemently disagree with every one of those occasions. We assert that he told the truth on all 4 of those occasions. Now, for the Commonwealth to tell the court in reverse order that there was some 24, 26 telephone calls from my client to Brooke Houp is absolutely false. My client lived with Joey. Joey was his son. He worked for Brooke Houp. Joey was called often by Mr. Houp and back and forth. My client had very little to do with Mr. Houp. He did a few plaster jobs for him, but he was not a full-time employee. He wasn't even a part-time employee. He did some work occasionally. And Judge, that's one of the 4 occasions. The other has to do with a telephone call to Brooke Houp on July 8th, 2015. The last occasion had to do with that skid steer. My client owned a one-half interest in that skid steer at one time with Mr. Thompson's son. He wound up with Mr. Thompson having the entire control of that skid steer. My client did not take that skid steer and use it as the Commonwealth claims that he used it. Now, it's awful easy to claim these things occurred and therefore he lied, but that is not the truth of the matter. I guess the court would have to hear detailed evidence about whether or not my client actually lied or not. But when they say that he lied and therefore he broke the agreement, that's not how the courts look at it. And I've cited cases to the court dealing with United States versus Fitch. And in that Fitch case, Judge, the court held that most important consideration, considering the immunity agreement, was the information that we supplied and whether or not the information was accurate and whether or not it led to the prosecution of Mr. Houp for murder. They received that information and they received other information concerning Joey. And in regard to the information that they received, they then turned their back on my client and reneged on their agreement. The case of Workman versus the Commonwealth is the leading case in Kentucky on immunity agreements. And it came out of Floyd Circuit Court, decided by the Kentucky Supreme Court in 1979. And in that case, the Commonwealth promised, if you take a polygraph and it was a murder case, you take the polygraph and you pass it, we'll dismiss the case. Commonwealth refused to do it. He was tried, he was found guilty, and the Supreme Court of Kentucky set the jury decision aside and held that, number one, the Commonwealth is the potent and omnipresent teacher for good or evil, teaches the whole people by its example. If the government breaks its word, it breeds contempt for integrity and good faith. The question is, we're dealing with a pledge of public good faith by a state official, and it should not be lightly disregarded. The attorney for the Commonwealth, with permission of the court, may dismiss an indictment prior to submission of the case pursuant to RCR 9.64. Judge, the court held that our historical ideals of fair play and substantial justice do not permit the Commonwealth to disregard its promises and fail to perform bargains. It doesn't permit the judge to allow such inequities to succeed. The government should not be allowed to well shun its bargain, citing the famous case by Olmstead versus United States, in which famous Judge Holmes dissented. And that case was also, the Workman case was reversed and the defendant was set free. Now, Judge, they cite two other instances besides the telephone call to Brooks Houp. Yes, there was a telephone call to Brooks Houp. I was present when my client told him about the telephone call to Mr. Houp. It had to do with securing an apartment for his niece. He doesn't deny that he called for that one purpose and that one purpose only.
Judge, just briefly, if he's saying that phone call was about obtaining an apartment, you're saying that's the truth?
Yes.
Judge, he testified in the grand jury that the phone call was to let Brooks Houp know that the job had been done.
See
He's under oath. This game of charades going on with Houps and Lawson, and what they're trying to pull is no different than what they've been doing the last 8 years. Joey Lawson, Steve told us, lived on Thompson Hill Road. He didn't live with him. Joey Lawson had his own phone.
That is exactly.
What Steve Lawson told us was he never saw those kids here. Never.
Judge, I hadn't finished yet. I've been interrupted, but
Okay.
I'd like to
All right.
proceed.
My understanding is you're saying that the phone call was about securing an apartment, and Mr. Young is saying he testified under oath that it was to let him know the job was done with the cars.
Yes, sir.
I'm not sure that was the same phone call or not.
What are we doing here?
Going in circles is what we're doing, but
Yes.
I'm gonna let him finish so I can make a ruling and get this thing over with.
Yes.
I'm not sure that was the same phone call or not, Judge, because I know he called, he said many times, I spoke with Brooke Houp about an apartment for my niece. And he Judge, that's been said time and time again in his interrogations with the Kentucky State Police. Now, he talks about a skid steer. Judge, my client used a skid steer to cut down some hay on some property owned by Brooke Houp on one occasion and one occasion only. And they're trying to tie him to the use of a skid steer, I guess, for the digging of some ground and the burial of Crystal Rogers. That did not occur by my client. He had nothing to do with that. He's told them I never harmed that girl. And he's told them over and over that. He said that these phone calls from the jail were with his former wife. And he said in those calls to the former wife that he did not in any way contradict himself on testimony or answers that he'd given in interrogatories at the Kentucky State Police post in Elizabethtown. It was all consistent. As I said, on numerous occasions, he was brought out of the interrogation room, told exactly that they didn't like what he said inside. They had a smoke. They went back in, and he was cautioned about telling the state police exactly what they wanted to hear. Now, Judge, if you read those interviews, take a look at that thumb drive that I gave you, if you look at that, I believe it to be consistent with what I'm proffering to the court today. I don't think that the case today should be judged on contract principles in the marketplace. The Commonwealth has an absolute burden of proving that we did not fulfill our contracts. We gave them everything the Commonwealth asked for. It led to the indictments of Brooke Houp and Joey Lawson. They received that information and went before the grand jury and obtained those indictments. And in doing so, my client gave them valuable information for which he was given immunity. And I believe the Commonwealth should have to live up to its bargain. They shouldn't be allowed to welsh on their deal. And I believe that in the event the court denies our right to dismiss this case, that none of these statements that of my client that were made during the bargaining process should be allowed to be entered into if we try this case under KRE 410, which provides that those statements are not admissible.
We're going to move on to that issue, the KRE 410. It's my understanding the Commonwealth agrees that the discussions on those dates, other than the grand jury testimony, would be inadmissible.
Up until, only thing that would be admissible is, I wasn't at the police on June 8th originally. I was at the office. When they hit Mr. Lawson up, he had asked for some guarantees to be made. At some point, I did go there. I think it was like a couple hours into the interview. Up until that point, Judge, I think those statements are admissible. Once I enter the room, I do make assurances to Mr. Lawson that statements he made during the interview process, statements he made to the detectives were considered pleading, and they did not. So yes.
So I'm just trying to understand. On June 8th, you're saying you think everything is admissible until you got there?
Yes.
Okay. So I assume that's on Mr. Lavitt's.
It is. Yes, sir, it is.
Okay.
I can provide all the way down if you want, but it is. If he provided all of yes, if you actually see me in.
But I think what you're saying is none of this would start till June 8th. So everything before that KRE 410 would be inapplicable as Commonwealth's position. Is that correct?
Right.
Okay. And then you're saying like the telephone calls to the jail obviously aren't plea negotiations or any of those.
That was actually after we had already told them we were done.
Okay.
Those were made in December.
So you're saying, when are you saying you said you were done? What date is that?
I texted Mr. Lavitt sometime in late November. Well, I will tell you the hard date is when I indicted Steve Lawson for conspiracy to commit murder. And that would be reflected in on the indictment.
Okay. So I think we got an agreement on 410, except for June 8th, up until you're saying you got there. And we disagree on the grand jury. If Mr. Lavitt's indicating he believes the grand jury testimony would be inadmissible also, but we believe.
I do, Judge, and I have cited the court leading case on that issue. The Diatonti case, United States versus Diatonti, 171 Federal Supplement 3rd, 477, 2016. Judge, that case said, number one, plea agreements are interpreted primarily according to the principles of contract law, while holding the government to a greater degree of responsibility than the defendant. And number two, when the contract involves a waiver of rights by the defendant and concerns about public confidence in the fair administration of justice, agreements between prosecuting attorneys and the defendant are analyzed with special scrutiny. And number three, that case further held that concerns about fairness and interactions between the prosecuting attorney and the public, the court will interpret the proffer between the parties according to the same amalgam of constitutional, supervisory, and private law concerns that governs the interpretation of plea agreements. It needs to be looked at with the same, and you've had lots of experience in examining these plea agreements, Judge, and it has to be looked at with the same scrutiny. And the question is, one of the fundamental doctrines is whether or not there was a meeting of the minds. This case also talks about KRE 410, and whether or not these grand jury statements are admissible. And as a general matter, I think we can show that that given the contents of the testimony, even if the indicting grand jury was presented with any statements under Rule 10, those statements should be protected.
Do you have any case where grand jury testimony fell under 410? Because I have found no case that says the grand jury testimony is precluded either under federal 410 or under Kentucky 410. Do you have any case that says that?
I just would ask the court to look at the concluding head notes of the Diatonti case.
We cited the Diatonti for no reason.
Okay. All right. And I believe the only other issue is there's an objection to the consolidation of the cases. If I understand your argument, Mr. Lavitt, you're wanting to use the same statements that you're wanting me to suppress. Is that?
Yes, I was, and if Mr. Lavitt would withdraw his 410 objection, I think that would accomplish everything in his consolidation motion, objection to the consolidation motion.
I guess, Mr. Lavitt, it looks like it's inconsistent to me. You're asking that I keep out all these statements, but then you say the cases shouldn't be consolidated because you want to use these statements. You see what I'm saying? It's an inconsistent argument. Which one are you wanting to do?
I have to wait for you to rule on this, on my motion to dismiss, Jerry.
You're talking about the immunity argument?
Yes, sir.
And then you're going to let me know which way you go if I deny that?
Yes.
Okay. All right. Is there any other issues we need to address today then? These motions? Okay. What the court's going to do is I'm going to take the matter under submission. I've got a lot of things to watch back on video, and I'll get a written decision out as soon as I can on the issues that are pending for us today. Thank you all.
Judge, that's all I have. Maybe
You all have a good day.